Parliament derives its authority from the people. Parliament for centuries now has had sovereign authority to pass any law whatsoever. No law that Parliament passes can be, quote, unquote, outside the law. In our system, it is Parliament which is supreme. This is very unlike the United States, for example, where the judges are able to strike down a law passed by Congress as unconstitutional. In fact, the UK legislature could actually do the opposite of that and strike the Supreme Court down out of existence if such were Parliament's will. The law is not the master of the people. It is a servant of the people, as this House is. It must serve the wishes of the British electorate.
Sir Michael Ellis.
Thank you very much, Mr. Deputy Speaker, and I rise to reject and oppose all 10 of the Lord's amendments. And in the other place last week, peer after peer spoke of this bill as an outrageous affront to the law or, quote, unquote, international law. And with great respect, there seemed to be a collective amnesia that it is Parliament that is sovereign, and that Parliament secured sovereign authority over generations from what had previously been, of course, an absolute monarchy, probably stemming from the Glorious Revolution of 1688. Parliament for centuries now has had sovereign authority to pass any law whatsoever. No law that Parliament passes can be, quote, unquote, outside the law. In our system, it is Parliament which is supreme. Despite the misnomer of the court that Tony Blair invented, it is Parliament that is supreme, not lawyers or judges. This is very unlike the United States, for example, where the judges are able to strike down a law passed by Congress as unconstitutional. In fact, the UK legislature could actually do the opposite of that and strike the Supreme Court down out of existence if such were Parliament's will. That is, after all, what Tony Blair himself did when he abolished the 150-year-old principle of the Law Lords and the House of Lords as our highest court, and created the Supreme Court just a few years ago. And many think that was an act of constitutional vandalism. But whether one does, and I happen to agree, but whether one does or not, it's axiomatic that what Blair did, one of his successors can, at least in theory, undo. That's the nature of our system. Parliament derives its authority from the people, and that is why parliamentary sovereignty is so important. It isn't an aggrandisement. It's because, as the member for Stone was saying earlier, it derives its authority from the people. And the law is a living and fluid concept, and people change and people's views change, which is why it is right that the people's elected representatives in Parliament can have sovereignty over decisions that are made. To give an example, 200 years ago, drawing graffiti on Westminster Bridge was an offence punishable by death. Now, one can block ambulances on Westminster Bridge and not even receive more than a small fine. The law has changed in 200 years, and it is imperative that we bear in mind that the law is a fluid concept. It has to keep up with the wishes and will of the people. And the point is that society changes and the law changes with it, and that is a major advantage of the English common law system. Today, Mr. Deputy Speaker, the British people have elected leaders, and my right honourable friend, the Prime Minister of this country, who advocate a policy of increased vigilance on immigration. And the elected politicians must be able to enact laws in accordance with the wishes of the people. And even if lawyers and members of the other place do not like that, that is the very essence of democracy. The law is not, and I've worked in the law my whole life. I was 30 years now since I was called to the bar. The law is not the master of the people. It is a servant of the people, as this House is. It must serve the wishes of the British electorate, and if necessary, adapt accordingly. The British people's current wishes on immigration are clear, and the Prime Minister is right to enact them. And this is not just a constitutional position. Mr. Deputy Speaker, 9 people have died trying to cross the English Channel in small boats this year alone. The latest victim of the smuggling gangs was a 7-year-old girl whose overloaded boat capsized in a French canal. So for this reason, stopping the boats is not just a political imperative, it is a moral necessity. And only when those coming to the UK illegally know they cannot stay will they stop risking their lives and the lives of others. Now, I'm sorry to say, Labour and crossbench peers in the other place last week, it's some sort of outrage to try to stop this trade in human misery by establishing what would be an effective deterrent through the Rwanda partnership. Now, in reality, despite the contributions of some members in the other place who were opposing this process, if one actually reads the Supreme Court's judgment last year, this bill, today's bill, is the constitutionally appropriate response to that judgment. The judgment related to the conditions in Rwanda at the time of the original challenge in June of 2022. And Lord Reid, the senior judge on the Supreme Court, was explicit that the issues identified could be addressed in future. In other words, the Supreme Court explicitly invited ministers of the Crown to remedy the problems that they had identified in their judgment. And that is precisely what His Majesty's government has now done, with a treaty that is binding under international law frameworks that Labour and crossbench peers so admire. So, nor does the Rwanda bill oust the jurisdiction of the courts. That's also a misapprehension. Judges will be able to consider human rights claims and judicial reviews. They will just do so after people have been sent to Rwanda, unless, of course, claimants can prove they will face a real risk of serious harm in Rwanda, in which case they can stay in the UK while the appeal is heard. And this is entirely...
You could mention the amendments now and again, that would be really useful.
Yes, well, thank you very much, Mr. Deputy Speaker. It is entirely reasonable. As I said at the beginning, these amendments are relevant to this whole concept. If one comes to this country illegally, one should not have the ability to repeatedly prevent one's removal at vast expense to the taxpayer. Yet because of Labour votes that were whipped, no doubt, by the Leader of the Opposition, the House of Lords defeated the government 10 times on amendments seeking to neuter the bill and ensure that no one is ever sent to Rwanda. They did not vote down the bill. They did not vote for these 10 amendments because they want it to work. They did so because they don't want it to work. And what none of those peers on the opposition benches did was provide an actual alternative to the Rwanda partnership. None of them could say how they will deter people from getting into overloaded dinghies on the beaches of northern France or prevent the deaths that will surely follow. So in voting against the bill, the Lords were therefore constitutionally, legally and morally wrong, and I urge the House to overturn their amendments today.